Okay, well, we're going to go ahead and get started. We appreciate you joining us for Get Real, and this topic is protecting your assets. I'm Kim Clark, and I'm the legal assistant with Martinez Law. We're going to do a quick round of team introductions, and then Cristen will start talking about the topic, and after that, we'll have Q&A. So really, the majority of the call will be Q&A, and it can be about this topic or any of your legal questions for Cristen. So Stephanie, do you want to introduce yourself next?
Sure. Good morning, everyone. My name is Stephanie Gibson. I am the COO firm. And what that means is I basically do everything but the actual work that the lawyers do. So if you need anything, you can definitely reach out to me with any questions you might have.
Tiffany?
Hi, everyone. I'm Tiffany McElherron. I am a partner with Cristen here at Martinez Law. I've been practicing for just about 10 years, exclusively in real estate, and I'm happy to be here.
All right, and I think I know all of you. I'm Cristen Martinez. Tiffany actually just joined us last month. We are super excited to have her with the firm. So make sure to reach out to her and introduce yourself. She can answer any questions that you have if I'm ever unavailable. But she's wonderful and we're so excited to have her. I'm going to keep my introductory portion extremely short. Let me take a look at these participants. I personally know every single one of you. And I think I've worked with all of you in the past. So I'm going to keep it very brief, but you all know about the firm. I always like to remind people that real estate agents, title companies, brokers, you have free access to me. You do not pay consult fees. So anytime you have questions, or Golf or Gilbert, if you have agents that you work with that have legal questions, give them my information. It's free to talk to me and get those questions answered. I'm happy to do it. I'd rather make you look good in front of your clients, and I'm happy to do that free of charge. So please utilize that. But with that, we will go ahead and get into the topic for today. Like Kim said, I'll keep it very brief. The goal of these calls is to get your questions answered, and that's what I want the main focus to be. I like to give some brief information in the beginning. Sometimes that kind of, trigger some questions that you may have in your mind as well. And also hopefully you can take home some good information with you. So I want to talk about protecting your assets, and the bulk of the discussion, I think she muted me. Okay. The bulk of the discussion is going to center around investment properties. So the homestead protection in the Florida Constitution protects your primary residence from creditors, potential liability, things like that. Primary residence means you live there a minimum of 8 months out of the year. So long as you do that, it's your primary residence. Whether you have applied for and qualify for the homestead tax exemption or not, that's something completely separate than the liability protection that your primary residence is afforded. So in certain situations, it does make sense to title your primary residence into an LLC or a land trust, but for the most part, we're talking about investment properties or anything other than your primary residence. So there's a few different ways that you can title it. The first thing that I always tell people is, if it's not your primary residence, you do not want to hold title in your individual name, no matter what. There are no exceptions to that. It is never a good idea. You either want to have it titled, there are many different options. The most common one is going to be an LLC. That's the most commonly used one. The corporate entity that I prefer is a Florida land trust. I work with both all the time for different reasons. Some clients prefer one over another, but I'm going to run through kind of what a land trust is, how it works, what the benefits are, and then I'll do a little bit of a comparison between a land trust and an LLC so that you can see some of the differences and why I highly recommend the land trust over the LLC. So with a land trust, a lot of the protections it provides you are the same as an LLC. So for example, it is going to protect your personal assets from any liability. That means if you have a renter in the property and they decide, they sue you, or they have a guest that comes over and injures themselves on the property, they're going to sue the property owner. So we want that owner to be a corporate entity with hopefully very little assets. Generally, that's how a land trust is going to work to protect you from your personal assets. They would have to file suit against the land trust versus you individually. Other benefits are you avoid probate. So if you were to pass away, the property would not be subject to probate. There are no annual fees associated with it. When you transfer title to the property, it's actually done via assignment. By law, it's seen as transfer of personal property instead of transfer of real property. So you're going to avoid dock stamp taxes and things like that. And the biggest benefit, in my opinion, especially for investors that have multiple investment properties, is that the true owner gets to remain anonymous. That is impossible to achieve with an LLC. No matter how many parent companies and subsidiaries you want to create, at the end of the day, it can always be tracked back to you here in Florida and how our system is set up. With a land trust, by statute, the beneficiaries, who are the true owners of the property, must remain anonymous. There are certain times that, those names will be divulged. For example, if you're going to apply for a mortgage on the property, your lender is going to know your true identity, but they are required by law to keep that information confidential unless a court tells them they are allowed to disclose it or they have to disclose it. So that's one of the biggest reasons why I like land trusts. The other reason is the practicality and how they are used. So with an LLC, and I'm kind of jumping ahead into my comparison, but this is the best way I know how to demonstrate this topic. So with an LLC, there is something called piercing the corporate veil. So you are required to keep everything segregated, all income received from the property, such as rent, all expenses paid on the property, whether that be taxes, insurance, maintenance, repairs, all of those funds need to be in a separate account and they cannot be commingled with your personal funds. If you were to commingle and use your personal bank account or your personal credit card to pay for expenses on the property, or deposit rental income into your personal checking account, for example, you run the risk of that corporate veil, that protection against liability, being pierced, which means that instead of the law seeing the LLC as a separate entity from you, the individual, if you're going to act like you're all one and the same, the law is going to treat you like you're one and the same, which means that that personal protection from liability goes away. So you have to be very careful. Most often when I see issues like this come up and corporate veils being pierced, it is by mistake. The clients know that they're supposed to keep everything segregated, and maybe a leak came up and it was an emergency and they got the plumber out there and their wife used the personal credit card because she was trying to take care of the issue as quickly as possible and didn't realize. It's usually something like that. So with a land trust, on the other hand, you never run that risk. From an accounting perspective, I would not recommend you commingle things no matter which entity you're using, but with a land trust, there is no corporate veil that can be pierced. So it's going to protect you even if you slip up and accidentally commingle or use personal funds for expenses on that property. So those are kind of the biggest reasons why I like land trusts. Another thing is, if you were to rent out the property or sell the property, you'll have designated with a land trust, you'll have designated a trustee. For most of my clients, my law firm serves as the trustee. So that means that anytime a document needs to be signed, it's my signature that would go on it on behalf of the beneficiaries. So you don't have to attend closing. You don't have to physically sign documents. It's a lot more convenient that way for a lot of people as well. So to kind of summarize, with an LLC, you're not going to get the anonymity factor. Your identity will be known publicly. It will be public record. Why that is important is because one thing that I do as a lawyer when I have a client come in and say, I have this issue, I want to sue this person, they owe me money. One of the first things I do is say, well, does this person even have any assets? Is it going to be worth our time and resources to sue this person? And if I look them up and I can track that they own 15 different investment properties, you look like a real nice target for me to go after and sue. If I search you and nothing comes up, it's possible you have assets, but we can't confirm it. And so it becomes a lot more difficult and you look a lot less attractive from a lawsuit perspective. So that is why that anonymity piece of it is so important. With the LLC, of course, you have your annual dues or fee that you have to pay to the state to keep it running and active. With a land trust, once it's set up, it's good for 30 years. There are no recurring fees with it. And then the last point was the practicality of using them. If you slip up, you commingle funds by accident. With a land trust, you don't have to worry about that protection being waived or pierced. With an LLC, that does become very important and very relevant. I'll wrap up with, and I guess I'll go ahead and jump into the Q&A portion, but when I talk about land trusts, almost every single person I talk about them with asks me, if I have multiple investment properties, should I put them all into one land trust or LLC, or should I split them up and open up a separate land trust for every property? The answer, of course, is it depends, but the most conservative way to set it up, or the way that you can set it up to best protect yourself, is to open up a separate land trust or entity for each property that you own, aside from your personal residence, of course. Because when an issue does arise and the land trust gets sued, if you have all of your investment properties in that one land trust and one tenant from one of those properties files a lawsuit, that subjects every single property owned by that land trust to that one lawsuit. We want to avoid that. And the way to do that is to create a separate entity for each different property that you have. Now, when you create a portfolio that, you know, we're looking at 10, 15 plus properties, sometimes practically it's difficult to manage and maintain that many different entities and bank accounts and things like that. So we can strategically group properties together to protect you in the best way as possible, while still balancing the ease of use and practicality of managing everything. But to best protect yourself, a separate entity for each different property is the recommendation. So with that, I will go ahead and open it up for questions. You can ask me questions about the topic that I've discussed or anything real estate related. I will do my best to answer those. And if you don't have questions, I have some very common and popular questions that I get, but I would rather open it up to you guys and see what questions you have for me.
So feel free to just jump in and ask your question, or if you prefer, you can send it through the chat. And also be sure to unmute yourselves.
I've got a couple of quick questions, if you wouldn't mind.
Sure.
Okay, so you know, we've dealt with land trusts quite a bit, and there's a couple complications that we run into. Primarily, banking is number one, because they're oftentimes looking for the land trust to have its own EIN number, where we're not getting an EIN number for the trust. So it usually has to flow through to the beneficiary's social security number. So we have found one bank that will actually open bank accounts in a Florida land trust, which has been complicated to actually find that. Well, it's there now. But the second thing is financing. So it's sort of a question for a mortgage lender, but we have been unable to finance in the name of the land trust. It has to go into the personal name and then probably get deeded back into the land trust. One of the questions that I've always had was the due on sale clause. Do you have any input as to whether or not that due on sale clause is triggered, because you do have a change of title?
I do, and I'm very glad that we have a couple of lenders on, but so they may have their own opinion on this, but technically, is that due on sale clause triggered if you deed the property from your individual name into a land trust of which you are the beneficiary? The answer is yes. There is a change in legal title, so that would trigger that due on sale clause. However, what I first recommend is you go to your mortgage lender for permission to do that up front. But in my 10+ years of experience in doing this, I have never seen a lender trigger any default of the mortgage based solely on that. So long as they are receiving their monthly payment, either they don't know about it or they don't care enough about it to trigger a default. If there is a default triggered, they will contact you and say, hey, this is a default of your mortgage. You have X amount of days to deed it back to the primary borrower. Gilbert, Golf, feel free to jump in with that, but it is a technical default, but in my experience, it has never been enforced. And I've talked to many lenders about that, and I've gotten that same answer from all of them. So if anyone else wants to jump in on that, that has been my experience.
Yeah, no, I agree on that. I mean, I think that's the correct answer. I've never seen it either. I mean, we advise, you know, I guess be forewarned, but I mean, it could, but I've never seen it happen in my 20 years. But I do have a question if I can ask, is that lately I've been getting conflicting answers from different title company about deed taxes, whether we're adding or removing someone on title. You know, some companies said, oh, well, you don't have to pay deed tax, and some does. So I'm just wanting to know what is the correct answer for that.
So there are certain exceptions on transfer taxes. So for example, in the case of a divorce, that would fall under an exception if you are removing one of the spouses due to a divorce. However, if you have a couple who has lived together and are in a romantic relationship but never legally married, so it's not subject to a legal divorce, technically that exception does not apply. So in theory, it's the same scenario, but you need that legality of marriage and subsequent divorce for that exception to kick in. There's also an exception, which this might go beyond the scope of your question, but if you are transferring property from your individual name into a corporate entity, so long as the owner or the beneficiary of that corporate entity is the exact same as who you're transferring it from, you don't pay transfer taxes. So if I'm transferring property that I own into an LLC where I am the sole owner or sole manager of that LLC, I don't pay taxes. However, if I'm transferring property that I own into an LLC that is owned by me and you, that's not an exact match, so that would be subject to the transfer taxes. So there are some exceptions that are at play when we're talking about transfer taxes. The biggest one is, upon divorce. And then the other one that I see most common is when you're transferring it to an entity where the true owner or the beneficiary is the exact same as the transferee or the grantor on the deed.
Okay. Just to clarify, so to relate on a most recent deal I had was a father and a son, right? And the father had moved back to Jamaica, but he was still on title on a particular closing I had. So then the title company charged the client a deed tax to take him off, even because he's not on the loan or anything like that, just to remove him. And I suggested, why cannot we not do a quick claim? And they're saying that, that's not the correct way. So I don't know. Can you clarify that?
So that is correct. So transferring it from father and son to son,
Only,
you
yeah.
will be paying transfer taxes on that. Now, I'm assuming no money is actually changing hands.
No.
So the transfer taxes would be based on whatever the mortgage amount is versus the purchase price like it normally is. So if there is no mortgage, there is no transfer taxes as well. So that's something else to keep in mind. If you're transferring property and there's no consideration, or the $10 is the consideration, and there's no mortgage, you technically pay transfer taxes on that $10. So your taxes are 70 cents. But without consideration, it would be based on any outstanding mortgage balance that there is.
Can I ask a third clarifying question on that then?
Yes.
In that situation, because we're going from two parties to one, both parties having an equal ownership, I guess you could say, do we pay a half of the mortgage, since we're like, you owe 50% of the value of this mortgage, since I guess technically your portion would be 50% of the associated cost, or do we got to cover the full doc stamps and intangibles at the, what, 55.55% on the whole thing. You're back. Nope, we lost you.
So you broke up a little bit. You broke up a little bit.
Uh-oh.
Frozen in time.
Am I back?
You're back now.
Maybe it was me that my internet connection, and that's why you were breaking up. So tell me if I understand your question correctly.
Yeah, so
Your question is if we're removing
what
somebody
is
from
our,
title.
yeah, if we're removing them from title, right? So normally you pay transfer taxes on, I guess, the value of sale or mortgage. Do we pay half transfer taxes if we're taking, let's say we have one party and we're removing one party? Do we pay half transfer taxes on the mortgage you're done? Or I've had title companies set it up different ways, and I'd just be confused. I'd be thinking to myself, I don't want to get involved in it because I don't want to tell a client the wrong thing because I don't know, But I've had different title companies try and bill them different ways on that. One will bill it for the full doc stamps and intangibles on loan, and others will do half the doc stamps and intangibles because they're moving the party. And I had one event where we were taking two people off title, and the title company was like, I think we only got a bill for 1/3 because we had three people on title, and one we had to bill for 2/3 or something like that of the outstanding mortgage because it wasn't dollars changing hands, it was just mortgage amount.
So if in the event of a divorce and we're removing somebody because of a divorce, transfer
this was
taxes.
Family, but non-divorce. Yeah.
Okay, so then you pay transfer taxes on the full mortgage balance. There is no divvying it up by percentage based on how many owners there are. In a divorce, you get a break. You only have to pay taxes on 1/2 of the mortgage balance. But if we're not talking divorce, you pay the full taxes on the mortgage balance.
All right.
But if they do it wrong and only charge you half, if you're representing the client that's retaining ownership, that could come back to bite them. So you do want to make sure it's correct, but.
Yeah, I talked to a firm yesterday who basically said, we don't have to collect the transfer taxes, but we're going to make them sign an affidavit saying they're not going to hold us accountable if the state if the state decides they want to come collect.
If they find out, they'll come back and collect them from you. Right, right.
So, I like that.
I imagine these are calculated incorrectly a lot, and it's just never discovered or found out by the state, and so nothing ever happens. But the correct way would be to pay it on the full mortgage balance.
Are the beneficial interests that you have in a land trust, if you're sued personally, are those beneficial rights, can you sue for that? Like if I'm the beneficiary of a trust and it's got $1 million in it, maybe it doesn't have any property, maybe we just sold some property, but we have a large stack of cash in there. Is that something that somebody can sue for? And because I'm a beneficiary, is that beneficial interest, is that something that they can sue for?
Yes, but only if you are acting in your capacity as beneficiary of the trust. So the trust would have to take some action that causes damage to somebody in order for that somebody to be able to sue the trust. If you're just out and about acting as Sam in your individual capacity, then no. It would have to be an action taken by the trust that directly caused that damage.
So would it be appropriate, I mean, I know this might be getting more granular, but would it be more appropriate to say, you have a trust, the trust that's where you put all your cash. And then when you go and you purchase a property, for example, you take the money from that trust and either lend it to a second trust or inject it into the second trust. That way the first trust is basically acting as a holding company or a holding entity. Would that be appropriate?
So you do not want to carry any sort of large balance in any of these trusts that are holding properties. You want to disperse that either to yourself, to a different entity. You want to loan against it because that counts as assets of the trust. So what you just said would be, yes, a very good way to protect those funds.
Now, an additional follow-up question to that would be the trustee themselves. Like, for example, you're the trustee on many of the trusts that we either own or operate, or you know what I mean? So the question then becomes, would it be appropriate to have a trustee that's a corporate, let's say an LLC, or like in your case, you have a PA, and I'm assuming, and I don't want to assume, but I'm assuming that when your firm is the trustee on these trusts, that entity that's the sole purpose of that entity, is to be a trustee. Is that correct?
Yes, so the trustee's authority to act on behalf of the trust is specifically stated in that trust agreement. So the trustee can never be sued or be liable for anything that the trust does. However, the trustee can be liable to a beneficiary if the trustee does something outside of that scope of authority, or in our land trust, for example, I cannot act as trustee unless I have specific authority from the beneficiary to do something or to sign something. So as long as I stay within those parameters, I'm judgment proof, basically. But if I go outside of that authority and do something without, beneficiary's consent, then I could be liable to the beneficiary, not to an outside person.
Okay, understood.
So going back to the transfer taxes, that's another benefit of holding property in a land trust, because in that example, instead of father and son being on title together, father and son would be beneficiary of the land trust. Father could be removed as beneficiary. The land trust still owns the property. So there is no transfer. There are no taxes due on it. So I briefly touched on that when I was going over kind of the general benefits of land trusts, but to give an example with it, you wouldn't have transfer taxes on adding or removing people if it's held in a land trust.
As a follow-up to Gilbert's question about, doc stamps and that kind of stuff, my understanding, and I could be wrong about this, is that if you assign a property out of a land trust to another, now you're transferring the beneficial interest, correct? That's what's actually being transferred? So technically, yes. Transfer of property, but isn't there a form or something that you have to file with the county stating that there's a change of beneficial interests?
No. So the first part of your question is correct. It's an assignment of beneficial interest, which by law is looked at as exchange of personal property, not a transfer of real property, because the property is still owned by the land trust and the name of the trustee. There is nothing that you would file, because remember, our beneficiaries are kept confidential. So there's nothing that we would need to file publicly to alert that there's been any sort of change. But it would not be subject to doc stamps in that scenario, because you are transferring or assigning technically beneficial interest versus transferring title to real property.
So the doc stamps would be due, is that correct?
Would not be due, no.
Okay. Even if it's a completely separate party, whatever, I want to transfer a property, for example, individually, then all I do is sign one piece of paper, which is an assignment of beneficial interest, and then that transfers essentially, because we're assuming in that scenario that the trustee remains the same, is that right?
Correct. And the trustee can change too. That's okay, because the entity, the land trust, is still going to be record owner of that property. So even if you're beneficiary of the land trust, and I'm going to pay you $100,000 and you're going to transfer me your beneficial interest, and you're going to be completely removed, that is still just an assignment of personal property. So there's no transfer of the real estate. There's no doc stamp taxes due.
Interesting. Okay, cool.
All right. What other questions do we have?
There's one thing I would point out, just it kind of dovetails on what Gilbert was saying, is that if you secure a mortgage, let's say, you have a personal, because everybody has to sign personally for these things, searching in the public records, and there is a mortgage taken out in your name on that property, even if you transfer that title to a trust, that's still public record that there's a mortgage holder. True anonymity as a result of cash purchase. Is that accurate?
So yes, the mortgages are always going to be public record. Mortgages typically aren't going to have the address, but if you're going to compare legal description to legal description, then yes, that is a way that you can ascertain who the mortgage holder is, who is probably going to be your beneficiary. There's no way to confirm that, of course, but that is a roundabout way that you can assume ownership of property. But you would have to know either the beneficiary's name, which you wouldn't, or you would have to know the legal description to even be able to search for that mortgage. Like you would have to have that information up front and then basically just try to confirm it based on whether there's a mortgage recorded in the name of that borrower. But that is a way that you could infer ownership.
And I've got one last question that I was thinking about, and that is, let's say that you own some property that's owned outright. But you were to place a lien on that property through one of your land trusts. Like you have a separate land trust, that land trust basically acts as a lien holder or a lender, and you slap a second lien or first lien against all of your cash, to be a first lien against all of your cash owned properties. What do you have to have a bona fide mortgage in place, or how exactly would that work to kind of protect yourself from being an appetizing target to, a real estate attorney, for example?
You should have a mortgage in place that is recorded, because if the entity were to be sued and there would be a judgment, that judgment would be subject to any liens recorded before that judgment was entered. So you want to be in that first priority position, or second priority, you want to be before that judgment is entered. And the way that you hold your spot is by recording the lien in public record.
I will tell you, Bill Steers, you guys know Bill.
Mm-hmm.
Bill Steers told me a few years ago that is how he holds investment property, land trust, and then he puts basically $1 million, a reasonably higher than the price value of the property lien against the property. He pays the taxes on that lien, when he records it, so that he can be protected from suit. Sure, sue me all you want. I owe more than I'm worth.
Right. But you do want to make sure you have the formalities of those documents in place and recorded, because you don't want it to appear that this is just a sham for you to avoid liability. You do want to make sure that it appears legitimate, that you're paying taxes on everything as if you would if it were an arm's length transaction.
Do you have to have a payment plan in place to do that, or could it be something where it's only paid upon exit, upon sale?
So it can be a balloon mortgage where it's only paid on sale or something like that. You do need to have some sort of repayment agreement in there, but it doesn't have to be like a monthly payment that you're doing and going through those motions every month.
Got it. That's great. Perfect. Love it.
Yeah, I got a question.
Sure.
Bringing all this with the land trust. I have a lot of people, doing the Airbnb, VRBO setup. And I have advised them, yes, to set up LLC or something, but now learning about more land trust. Is that only specific for Florida or other states? Same rule?
So the land trusts are specific to Florida. There's a whole chapter of the Florida statutes dedicated to how they're set up, how they work. I believe 30-something states have their own land trust statutes, but I don't know how much they differ as far as how they work. Not all states recognize them. A slight majority does recognize them, but they're going to have their own written statutes that are going to govern how they work and how they're set up and things like that.
Okay. Thank you.
All right. Any other questions?
Any questions?
All right. Well,
Can I just ask one more question, Cristen?
yes, sure.
I'm sorry. You had mentioned that the land trust can avoid probate. Is there ever a time when probate would be a good thing to go through with your properties? Like if you want to step up in basis or something like that?
So I'm going to preface this answer with, I don't do probate work. So this is probably a better question for an estate planning attorney. I mean, it's going to depend. For typically no, when it comes to real property, because probate is going to take a long time and it's going to add expense. So the reason why you want to avoid probate is because as soon as the beneficiary or the owner of an LLC passes away, if you're set up properly, the transfer to the successor will be automatic upon recording of that person's death certificate. So they don't have to wait for this process to go through before they can start maintaining the property and paying insurance and doing all of these things on it. So based on my surface level knowledge, no, but I would check more with a probate attorney on that. I don't see any benefit when it comes to real property. So I feel confident in that answer. When it comes to other things, I'm not really sure.
Awesome. Okay, great. Thank you.
Great. Well, thank you all for coming. I know you all have my direct contact information. So if you think of any other questions, feel free to shoot me an email or give me a call. Kim, do you want to go ahead and announce our next month's event and all of those details?
Sure. So this is a monthly roundtable discussion. As you can tell, it's super informal. So we hope that you'll join us again, always on the first Wednesday at 10:30. So next month is February 3rd, I believe, and the topic is evictions, the ins and outs of evictions. So thanks for coming, and feel free to share this information with anyone in the real estate industry. It's appropriate for anyone. And our registration is on an Eventbrite, but we also post that on our social media.
Awesome.
Thank you, Kim. Thank
Really
you guys for
appreciate it.
coming. I appreciate you all.
Thank you.
All right. Have a great day.
You too.
Y'all
Take care.
too. Talk
Bye.
to you later.